morning, Mr. Chairman.
This is an appeal in the matter of Marsh Ltd and Norman Hay Plc.
Good morning, my lord. My lords, I appear with Mr. Hamish Fraser for the appellant defendant, Marsh Ltd. And my learned friends, Mr. Graham Chapman, King's Counsel, and Miss Mary Claire O'Kane, appear for the respondent claimant, Norman Hay Plc. This is an appeal from Mr. Justice Picken, made with permission given by the learned judge against his order of the 8th of May, refusing Marsh's application for reverse summary judgment.
Yeah. Can I just say two things?
Yes.
One, there won't be any breaks for the transcript writers. And two, we will be rising for lunch at 10 to 1 until 10 to 2, eccentrically, today.
No problem at all, my lord.
Okay?
I'm grateful. The application for summary judgment was made on two distinct bases, both of which are before this court, and a third basis which isn't before this court. The first basis is...
You're going to have to keep your voice up a bit, Mr.
I'm so sorry.
We always have quite a lot of competition from outside.
I'm so sorry, my lord.
It's all right.
There are two bases. The first basis is that Norman Hay's claim cannot succeed on causation because it, Norman Hay, has no liability to the third-party claimant, Ms. Heather Sage. Therefore, Norman Hay would not be entitled to indemnity under any non-owned auto liability extension, even if Marsh had placed such an extension. Accordingly, the orthodox claim against an insurance broker, a claim for breach of duty for failure to place insurance, cannot succeed. And that's because it concerns the absence of any legal liability of Norman Hay to Ms. Sage that's come to be referred to as the liability issue. But of course it is an issue of causation, and it gives rise to the significant issue of principle before this court. Ground one of the appeal, the correct approach to causation in insurance brokers' negligence cases. Grounds of appeal 2, 3 and 4 also relate to the liability issue. The second basis of the application is that Norman Hay's claim cannot succeed because Norman Hay, as opposed to other parties, did not suffer any loss. By a sale and purchase agreement, Norman Hay sold its subsidiaries to Quaker Specialty Chemicals Limited for the sum of around £80 million, less the equivalent amount of, in GB pounds, of US dollars 8 million. And that US dollars 8 million of the agreed sale price was paid by Quaker into an escrow account. 5.5 million US dollars of that sum in the escrow account was then used to pay the settlement sum to Ms. Sage. Interest on that 5.5 million US was paid back to Quaker. The remaining US 2.5 million in the escrow account was paid to Norman Hay, being the remaining balance of the purchase price, along with interest on that 2.5 million. And the reduction in the purchase price, in my submission, reflects that the loss was suffered by the subsidiaries. In the sale and purchase agreement, Norman Hay agreed to indemnify Quaker and the former subsidiaries in respect of their liabilities, the liabilities of Quaker or the former subsidiaries, to Ms. Sage. Such indemnity was only to be made from the monies in the escrow account, i.e. the reduction in the sale price, and only to the extent of the US dollars 8 million in the escrow account. Norman Hay agreed the indemnity, limited to the amount in the escrow account, precisely to indemnify loss that was properly its former subsidiaries and would otherwise be suffered by Quaker after Quaker's acquisition of the subsidiaries, because at the time of the acquisition, the settlement agreement hadn't yet been entered into. That the funds for the escrow account were from a reduction in the purchase price, and the agreement for the indemnity, in my submission, reflects that any loss is not Norman Hay's, but a loss of the former subsidiaries. and Norman Hay obviously cannot recover loss suffered by its former subsidiaries. To the extent any loss has been suffered by Norman Hay, it was only suffered as the shareholder of the subsidiaries. It was a reduction in the price paid by Quaker for the shares of the subsidiaries, which is neither a recoverable nor indeed a pleaded head of loss, and grounds of appeal 5 relates to the second basis. Subject to your lordships, I intend to give a very brief introduction to the facts, then to identify the legal basis of the liability issue, and then to take grounds 1 to 4 in order, but spending considerably longer on ground 1 than 2, 3 and 4. And then I propose to address the loss issue in ground 5. Ground 6 will be wrapped up in the other grounds. In terms of the brief facts, Norman Hay was a holding company for various subsidiaries. The subsidiaries were the operating companies operating in the chemicals industry. Marsh was retained as an insurance broker in June 2017 and instructed to put in place a global insurance program. Later in 2017, after that program had been put in place, Norman Hay acquired a German subsidiary, IMP. IMP at that stage had a German liability policy, which included an extension providing worldwide non-owned auto liability cover up to a limit of €3 million. Non-owned auto liability cover is essentially motor liability cover for employees using hire cars or their personal cars for business use. Such extensions, and particularly worldwide extensions, are entirely typical in German liability policies. They're not typical, and certainly not worldwide extensions, in English liability policies or London market policies.
So what's the allegation that you should have placed by way of cover?
That we should have placed worldwide non-owned auto liability cover for Norman Hay.
On the terms of the previous policy?
It's not been we asked a Part 18 request of asking what the terms of the cover that we should have placed would be.
So how can this case be determined without finding the facts as to what you failed to do?
Well, one answer to that, my lord, is that any type of liability cover has to be against a legal liability in law, and therefore the first ground of appeal and the issue, the legal liability issue, is a convenient way of disposing of the dispute. But it's certainly correct that we asked a Part 18 response. It's in the supplemental bundle behind tab 5, and we were told in bland terms, we've pleaded what we've pleaded, and to emphasise that point, there were a series of answers cut and paste from paragraphs of the particulars of claim.
So are we going to look at the particulars of claim?
My lord, yes.
Page 73 in the court.
I'm very grateful. It's paragraph 25.
Is it?
I'm sorry, my lord, I'm having a small computer issue. If your lordship will give me a moment. May I ask your lordship to turn up page 83?
I'm on page 83.
And it's paragraph 25.
Mm-hmm. That's not about what you should have placed.
The intention of what we should have placed is under the particulars of breach of duty at 35, paragraph 35 on page 86.
Yeah.
Subparagraph 3, failed to arrange insurance policies in accordance with the claimant's needs or to take reasonable steps. In particular, having failed to identify the need for cover extending to the use of hired vehicles in the USA, no such cover was placed as part of the insurance arrangements placed by the defendant, and no adequate advice given in respect of the same.
And what do you say in answer to that?
In terms of the breach, what happens is that we are given a direction to subsume effectively the insurance of IMP into the global program.
Sorry, say that again.
Sorry. At the 2018 renewal,
Yeah.
the following year after IMP is acquired,
Yes.
we're given an instruction not to renew the IMP policy, but to put IMP onto the global program of insurance, which we do. And there will be, if this matter goes to trial, a debate about whether that was the right thing to do, what instructions we were given, and how we followed them.
Yeah, that's all facts.
That's all facts. And the reason that the summary judgment application is made on the causation issue is because that is a legal issue and not an issue of fact. We can't, however much we regard this as an unmeritorious claim, we can't make a summary judgment application in relation to breach because it would be on the facts.
Yeah, but my concern is this. If we don't know what facts are going to be found as to what instructions you were given, what advice you gave, what discussions there were, and what policies were available in the market that you might have advised your client to take, how can we say that if, as alleged, you were negligent in not advising them to take a policy, that policy would not have covered this loss, because we don't know what the policy was?
Because the answer to that, my lord, is that any policy would have been a liability policy.
Well, is that where you plead? Where do you plead that? That's what I'm looking for in your defence. Do you plead any policy would have been a liability policy which wouldn't have covered Norman Hay against this loss?
May I just ask, I know it's interrupting, forgive me, but I would like you to deal with para 37 particulars of claim, either after you've answered my lord's question or because it seems to deal with the point that you're discussing. As I understand, that's where the causation argument is pleaded by the claimant. And then it'd be interesting to see what your defence says about it.
Well, while we're on page 88, may I deal with that, and then may I come back to my lord, if that's convenient.
Yeah.
At paragraph 7, it says, but for the defendant's breach of the duty as set out above, the claimant and or IMP. And there is no claim by IMP. IMP was Mr. Kelsel's employer, allegedly. He was an independent contractor, but there's a dispute between the parties as to whether or not he was the employee. For the purposes of this application, it needs to be assumed that he was.
Sorry, he was what?
Mr. Kelsel
Yes.
was the employee
Of
of
IMP.
IMP,
Yes.
but not the claimant.
Yes. But so what? I mean,
Because-
the claim is that the claimant would have had in place effective insurance cover that would have provided an indemnity in respect of liabilities to Sage arising from the accident.
My lord, respectfully, no.
Well, that's what's
What-
pleaded.
My lord, and or IMP. If it was just pleaded the claimant would have had in place cover, that's a very different thing. So IMP did have that cover under the German liability policy, and IMP might have been able to make a complaint against us about the loss of that cover And further, if anybody was going to be liable to Miss Heather Sage for the accident, there being a dispute about whether he was on a business journey at the time of the accident, it would be IMP. So if this claim had been brought by IMP...
Well, of course we understand that. Of course we understand that, but it's not, because of all the machinations that occurred, which you tried to tell us about a few minutes ago. The escrow account and all that.
Yes, but it was a question for the claimant, who was advised by lawyers at every stage how they arranged things.
Yes.
And if they have arranged things so that they are now in a position where they cannot bring the claim because they do not have any liability to Miss
So he
Sage.
cannot bring which claim against whom? Which claimant? This claimant?
This claimant
Norman Hay.
cannot bring a claim against Marsh for failing to provide it, the claimant, with liability endurance, because on any view it had no liability to Miss Sage, and it doesn't suggest that it did. It's expressly declined and refused to plead that it did.
I follow that, but isn't it all rather unreal if there had been an insurance policy in place in which both Norman Hay and IMP were named as insureds, and it was Norman Hay who had made the claim? The insurers might have taken the point, aha, it's not Norman Hay who's liable, it's IMP. Or they might have said, well, it doesn't really matter to us, we're liable to somebody, we'll pay the claim and take a discharge from both of you. If the latter, well, the money would have been paid and the problem we have wouldn't have arisen. But if they had taken the point, you're suing in the name of the wrong claimant, then it would have been a simple thing for Norman Hay to take an assignment of IMP's claim as part of what my lord has called the machinations, i.e. the arrangements when the subsidiaries were sold, so that Norman Hay would have a valid claim. I mean, one way or another, the insurers, assuming Mr. Kessler was an employee and assuming he was negligent and so forth, the insurers would have paid, or would have been liable to pay, wouldn't they?
Well, there are two things in relation to my lord's question. The first is they would have been liable to, assuming he was an employee and assuming he was on a business journey, they would have been liable to indemnify IMP as an insured under the policy. And that's the basis on which they would have paid. The second point is, of course, you could have entered into an assignment. I mean, that's one of a number of ways one could have dealt with this, but it wasn't dealt with that. There is no assignment.
Well, there was no policy, so there was nothing to assign.
Well, there was
if there had been a policy, it would have been straightforward to sort it out, wouldn't it? And isn't that something that needs to be investigated as a matter of fact at a trial?
There was a cause of action which was known about. The letter of claim had already been sent. The likelihood of the settlement was known about, which is why it's dealt with in the SPA. So there was a chosen action which could have been assigned, but wasn't assigned. They chose to deal with it in a different way. Or they effectively chose not to deal with it in an effective way. So, my lord, I agree with my lord's point that it could have been sorted out, but it has not been. And in the position that we are in now, this claim doesn't work. And in my submission is susceptible to summary judgment. And that should have been granted rather than leaving us to go down to trial at great expense and court time.
For the amount you spent, you could have had a trial by now. You might have won.
Well, my lord, respectfully, not on the amount spent on this side.
Well, either way, anyway, you carry on. I mean, I would quite like to see what you plead to paragraph 35 and 37.
Yes, my lord, sorry, I got distracted by
No, that's all right.
my lord, Lord Justice Birss's
Well, I
question.
don't think that was quite fair. I think the Lord Justice Birss simply
Well, I
pointed out
gave the answer first.
a relevant pleading.
I apologise, I didn't mean to ignore
Yeah.
the question. So in the defence, which starts on page 93 of the core bundle, we identify, we've asked a request for further information or clarification at paragraph 5, and we haven't got an answer.
No,
And then
we're not dealing with that.
at paragraph 9, at the bottom of page 94, we identify the claim is for the alleged loss being the safe settlement sum and the claim's legal costs. And we identify that any sums paid into the escrow account were not paid by the claimant but by the buyer. We refer to responses 32 and 33, from which it's reasonably inferred the claimant did not itself pay the settlement sum, but it was paid out of monies provided by the buyer, Quaker. We then identify that the claimant's alleged loss is effectively for the receipt of a lesser sum from the buyer for the claimant's
Yeah,
decision.
well, that's just pleading the points that you're appealing. But what I'm interested in is your answer to the claim of breach and causation. And that, I think, is a bit further on.
And at 14, we identify it as not pleaded that the claimant was legally liable to Miss Sage, and the claim accordingly fails.
Yes, well, we know that. That's the subject of your appeal. But where is the...
It's paragraph 72, isn't it? That's where you get into the detail of breach.
Yeah, well, it's very long and involved, yes.
Well, it's partly long and involved because as the original allegations are fairly vague, one has to cover all the basis in response to them. We did seek clarification.
Okay, well, I mean, just going back to the particulars of claim, paragraphs 35 and 37 don't seem that vague to me, but there we are. 35 makes an allegation that you negligently failed to assess the needs of the claimant and recommend insurance policies that met those needs, and didn't place the cover that they needed. There's a lot of other allegations. And then 37 says that had you placed the cover, they would have had, the claimant and or IMP would have had an indemnity in respect of the liabilities to Miss Sage by hook or by crook, effectively.
Well,
And they wouldn't have had to put a great sum in escrow and cough up.
well, they didn't put the sum into escrow. The sum was put into escrow by Quaker.
Of course, but it was out of the money they paid.
My lord, the answer on breach is set out at paragraph 72, and in relation to the position, It's essentially we placed the insurance for the needs we were told about, specifically the business travel we were informed about. We weren't told that there was hiring of cars.
But that's a fact.
Well, I'm conscious that it's
You're not appealing the facts. You're appealing a sort of a very specific legal point, which you have to win if you're going to strike this claim out.
My lord, yes.
And you're asking the court to assume that all sorts of facts will be shown to be the case when what is said against you is really very general. It said that all sorts of things happened and you should have given advice and placed a policy. We don't quite know what kind of policy. And had you done so, it would have responded, or we'd have got some money from insurers. And you say, no, you wouldn't, because the liability policy that would have been placed, which is not what is precisely alleged against you, would not, could not have responded ever in the history of the world. And that may be true, but it's something that could only be seen clearly after a trial, when we know what the facts were. I mean, you may not be liable at all. I mean, I could, in a way, I'd completely understand if you'd struck this out on the basis that here's the email, you asked us to place this cover, you didn't ask us to place cover about hire cars in America, and there we are. That's a different point.
Well, there would still be an investigation into the demands and needs. My lord, in answer to my lord's earlier point, it's not any type of cover within the panoply of all insurance cover.
So where is it pleaded? Where is it pleaded in your pleading that the only type of cover that could have been obtained or would have been obtained is X, and that would not, under any circumstances, have responded? I mean, I understand your point about it not responding to the claimant. I get that point.
Well, that was the paragraph at 14 that I asked.
14, yeah.
Paragraph 14.
Page.
Page 80. 95.
So it says that they weren't liable to Miss Sage.
Well, it says at B, Little Roman 2, my lord, the claimant would not have been entitled under any liability insurance policy to any indemnity for the Sage settlement sum or any payment made to Miss Sage, as a liability policy only indemnifies an insured for legal liabilities to a third party for injury and consequential loss.
Okay.
I
understand that.
The claimant cannot claim from the defendant for alleged failure to place additional liability insurance. And we put it in that terms because it's been put in vague terms to us. Additional liability insurance cover, where any such liability insurance cover would not have provided indemnity. So it's not a point specific to any particular liability policy, although if one looks at I accept it's under German law, but if one looks at the IMP policy, it requires legal liability. The short point is any liability policy requires one in English law to establish a legal liability, because that's the law and the nature of the wording, and one doesn't need to be any more specific than that. But if I can take you also to page 113, please, and to paragraph 76A.
So, interestingly, the reply, I'm sorry to take you out of your course, but the reply to the paragraph on which you place your reliance, at page 122, in paragraph 14 of the reply, says they were advised to enter into this settlement on proper legal advice, but further, paragraph 37 of the particulars of claim pleads that but for the defendant's breach of duty, they would have had in place valid and effective insurance cover that would have provided an indemnity in respect of liabilities to Miss Sage arising from the accident. The claimant's case is that as a result of the defendant's breach of duty, it didn't have insurance cover to respond to the liabilities when it would otherwise have done so. So that's the case you have to meet. And what I find difficult at the moment is, without going through, trawling through all the instructions you received and all the responses you made and all the possible policies that might have been in place or not in place, we can say that there is no such thing as such cover, which would have responded by way of either responded because of a commercial reason or responded as a matter of law.
Well,
I mean, without knowing what the policy is that's being placed, how do we know?
my lord, until this morning, nobody has been disputing that point because everybody's understood that it has to be a liability policy. It's a liability policy ultimately to protect Mr. Kelsall against his liability in negligence to Ms. Sage. So it must be a liability policy of some form. And that's
The allegation against you is that the holding company and or IMP would have been covered to deal with this problem. That's the allegation. Maybe complete, if I can be rude for a moment, maybe complete nonsense, but that's the allegation.
But yes, and the difficulty with the allegation is certainly IMP might have had a policy, and because IMP can be argued to be Mr. Kelsall's employer, that policy might well have paid. So if IMP was bringing the claim on my Lord Justice Mayall's suggested route, the claimant was with an assignment of IMP's claim, this problem wouldn't arise because one could simply say IMP was, Mr. Kelsall was in fact legally liable to Ms. Sage for the accident. IMP was legally liable to Ms. Sage, vicariously liable for Mr. Kelsall, and therefore the liability policy, if we'd had it, would have paid. What cannot be said here is that the claimant was legally liable to Ms. Sage because they don't have any link through Mr. Kelsall, and nor is it alleged that they do, and nor will it be pleaded at trial that they do. And certainly there's a reference back to paragraph 37. If one looks, we're currently at 14 of the reply, the claimant and or IMP, if one deletes and or IMP, because they can't claim on behalf of IMP, the claimant would have had in place valid and effective insurance cover that would have provided an indemnity, so necessarily it's an indemnity policy, and it must be against the liabilities in the accident, because it says in respect of liabilities to Ms. Sage arising from the accident. So the claimant is pleading that they would have had a liability policy in place. We say it would have to be a liability policy. There isn't, in my submission, the doubt as to what the policy would have been that my Lord has suggested this morning. Everybody pleads and accepts it would have been an insurance policy against liabilities. And that's as much as one needs to know for the argument in ground one to work.
You emphasise the last sentence of paragraph 14 of the reply, do you, where they say the claimant's case is that as a result of the defendant's breaches of duty, it, i.e. the claimant, did not have insurance cover to respond to the liabilities of the Sage.
Yes, and I also emphasise the second it, when the claimant otherwise would have done so. So at least according to the last sentence, and for the avoidance of doubt, the claimant's case is that our alleged breaches of duty meant that the claimant, Norman Hay, did not have insurance cover to respond to liabilities to Ms. Sage. Necessarily, it must be a liability insurance policy, when the claimant otherwise would have done so. And we say that that claim is bound to fail, because the claimant not only doesn't have a liability to Ms. Sage, but has expressly disclaimed, for perfectly obvious reasons, any attempt to plead or subsequently prove a liability to Miss Sage. If the point's a good one, then it should dispose of the claim now, before we all incur the costs of going through to trial. If the point's a bad one, of course, we have to go to trial. But the point can, in my submission, certainly be decided. And there isn't the doubt as to which policy it is. I understand, of course, coming to this case, why it could look like there was, but there isn't the doubt as to which policy it is that my Lord has suggested. My Lord, I apologise. I'm not sure if I've now properly answered your question or not.
No, I'm sure you have answered the question.
My Lord, may I return to the facts, because we've delved into them and it's just useful to have them clear in one's mind before discussing this. Mr. Nigel Kelsall is the person who was very unfortunately killed from his injuries in the accident. He was an independent contractor of IMP, but for these purposes, while it's in dispute, it should be assumed he is an employee of IMP. In November 2018, in the run-up to Thanksgiving, he was on a business trip to the US for IMP, but at the back end of that trip, before flying home, he went to visit two friends to see them and their families, and a Mustang vintage car that was being restored by one of them. And after staying overnight at the home of the second family, he got up and tried to drive to the airport, leaving at 6 a.m. And unfortunately, about 5 minutes later, slightly down the same road, he had an accident where he crossed onto the wrong side of the road and crashed into Miss Sage. And he died from his injuries. Miss Sage was seriously injured. So in terms of the accident, there is unlikely to be any dispute as to whether he was negligent. He unfortunately drove on the wrong side of the road. He hadn't taken out, when he hired the car from Hertz, or rather from Thrifty, a subsidiary of Hertz, liability insurance. And in the US, unless you tick the box for liability insurance, you don't have it. So he was uninsured. And as a result, it was clear that Miss Sage was going to sue anybody and everybody who she could. And a claim was threatened, amongst others, against Mr. Kelsall's estate, IMP, various US subsidiaries of Norman Hay, and Norman Hay. In early 2019, so about 4 months after the accident, Norman Hay, by Mishcon, sent a letter of claim to Marsh, and then subsequently, in October 2019, one had the sale and purchase agreement, on which they were advised by other lawyers, and by which Norman Hay sold the subsidiaries, including IMP, to Quaker. And as I've said earlier, under the SPA, there was 8 million US of the 80 million GB pounds purchase price put into escrow, and there was the indemnity agreed for Norman Hay to indemnify Quaker and its subsidiaries against necessarily their liabilities. Otherwise, you wouldn't need the indemnity. In response to the letter of claim, Marsh queried, it's tab 2, page 58 of the supplemental bundle, but there's no need to turn it up, on what basis Norman Hay, as a holding company, was claiming, given it did not appear to be legally liable to Miss Sage, and why Norman Hay was claiming losses which, if suffered at all, could only be IMPs. So these two issues have been known about right from the start, right up against the SPA, and we're coming to them now 6 years later, but they were identified in the very beginning. In November 2020, Ms. Sage brought a personal injury claim in Ohio against IMP, the US subsidiaries, a number of John Doe corporations, and Norman Hay. No defences were served. Norman Hay has not waived privilege and refuses to waive privilege over any US or Ohio legal advice Norman Hay received in connection with Ms. Sage's claim. Norman Hay and its subsidiaries entered into a binding settlement term sheet by which Norman Hay agreed to pay Ms. Sage on behalf of everybody US dollars 5.5 million. That's paragraphs 3 and 9 of the term sheet on 198 of the supplemental bundle. And then some of those terms, but not the payment terms, were then embodied in a more formal settlement agreement, which is at page 186 of the bundle. And the settlement sum was thereafter paid from funds which Quaker had paid into the escrow account. And Norman Hay accepts the settlement sum was paid by Quaker. If I could ask your lordships, please, to turn up the supplemental bundle behind tab 3 on page 81. This is the witness statement of Mr. Nielsen in response to the application. And at paragraph 19G, he records, accordingly, this resulted in a lesser purchase price ultimately being paid to the claimant, equal to the amount of the Sage settlement sum. This is the loss that has been sustained by the claimant, which it seeks to recover. And then, last sentence of paragraph 21, the fact that the payment of the Sage settlement sum was not physically transferred from the claimant itself to Ms. Sage, but instead took the form of a reduction on the sale price paid pursuant to the contractual mechanisms of the SPA, does not establish that the claimant has not suffered any loss. And at 22, last sentence, the fact that such loss manifested in the form of a reduction in the purchase price obtained upon the sale of the companies, rather than a direct payment by the claimant to Ms. Sage, is of no relevance. But it's accepted that this was a loss which reduced the purchase price of the shares of the subsidiaries. And it precisely reduced the purchase price of the shares of the subsidiaries because it is the loss suffered by the subsidiaries. With that brief factual introduction, may I then address your lordships on the liability issue, which was the first basis on which Marsh sought reverse summary judgment. And the alleged breach, I hope I have established, was a failure to arrange liability insurance, which would have indemnified Norman Hay for its liabilities to Ms. Sage. That breach is only causally relevant if Norman Hay would have been entitled to indemnity under such liability insurance, because to recover under a liability policy, an insured has to plead and prove that it was in fact liable in law to the third party. An insured cannot simply rely on the fact of the settlement to demonstrate either liability or that the amount of the settlement was reasonable. That was originally Mr. Justice Aikins in Enterprise Oil and Strand, paragraph 27, page 58 of the authorities bundle. It's not sufficient merely that liability is alleged. Same authority, paragraph 65, page 64 of the authorities bundle. And it's not sufficient that a jury in the US might be likely to find or could have found the insured liable. An English court will decide what the outcome of the case should have been, applying US law correctly to the facts as found by an English court. And that's paragraph 82 of Mr. Justice Aiken's judgment, page 68 of the authorities bundle. Those principles have been confirmed by this court in AstraZeneca and XL Insurance. And that is, and may I ask your lordships to turn to it, in the authorities bundle at tab 9, page 168. Briefly, AstraZeneca claimed under an insurance policy underwritten by AstraZeneca's captive insurer for the settlements AstraZeneca had entered into with third-party claimants in respect of Seroquel. It was a drug manufactured by AstraZeneca, which was attracting a lot of litigation in the United States. The claimant before the court was AstraZeneca's captive insurer, claiming under its reinsurance from the defendant reinsurers. To recover under the reinsurance, necessarily the captive had to prove that AstraZeneca had been entitled to cover under the insurance policy. But the captive pleaded only that it was alleged by the third-party claimants that AstraZeneca was liable to them. The captive did not plead and therefore would not be seeking to prove that AstraZeneca was in fact liable to the third-party claimants. And this court held that AstraZeneca was not therefore entitled to cover under the captive insurance policy. And accordingly, the captive was not entitled to indemnity under the reinsurance. If I could ask my lords to look at paragraph 16 of the judgment of Lord Justice Christopher Clark on page 174. It's the first two sentences. And then in paragraph 17, the second sentence, it's not therefore necessarily sufficient for the insured to show that he has been held liable to a claimant by some court or tribunal, or that he has agreed to settle with them. In practice, the fact this has occurred may cause or persuade the insurer to pay, but if it does not, the insured must prove he was actually liable. Under English law, the ultimate arbiter of whether someone is liable, if insured, an insurer cannot agree, is the tribunal which has to resolve their disputes. It may hold there was in fact no actual liability, and that an insured who thought, or another tribunal which decided that there was liability, was in error either on the facts or the law or both. And then he recognises that the principle is potentially very inconvenient for insureds, but it is nonetheless the principle. He then identifies at 19 there are ways of obviating or reducing these difficulties. And then if I could ask my lords just to read paragraph 21, please, over the page on 176. And the first sentence of paragraph 22. There's then a summary of the principles taken from the Omega Proteins case.
But none of these principles are in dispute. This is not a claim against insurers. This is a claim against insurance brokers.
But in order to recover against any insurer who would have written a policy.
Yeah, you've said that. We know that.
And if the broker fails to put in place a policy, the proper question is, had that policy been in place, would there then have been cover under that policy? That's the first question to be asked. And if the answer is no, there wouldn't have been, then there's no breach on the face of it. Now there's then a second question which arises.
But a prior question is, what policy was the broker supposed to put in place? You've said that it's all very vague, but paragraph 19 of this judgment you've taken us to suggests that there are other things than, strictly speaking, liability policies. There are apparently claims made policies or occurrences policies.
Certainly, my lord. But the pleaded claim against us is we failed to put in place liability insurance.
Well, the pleaded claim against you is not that clear, as you have pointed out in extenso, if we're allowed to use Latin. It said that you should have put in place cover that covered Norman Hay and or IMP against what happened. And they say they've lost the chance of it responding.
Well, my lord, we looked earlier, it's in the core bundle on page 122, paragraph 14 of the reply, where it says, for the avoidance...
Paragraph 14 of the reply is not the claim. The claim is in paragraph 35 and 37 as the brief. We don't need to go back over it, we've read it.
Well, my lord, may I take you to the particulars of claim then, if the reply is, and to page 79 of the particulars of claim, in the core bundle. Paragraph 6. The complaint is about the global liability program. It's not suggested there should be other cover. At paragraph 7, the relevant cover is to the liabilities arising from Mr. Kelsall's accident, which must be liability cover. That's 4 lines up from the bottom. But for the defendant's breaches of duty, valid insurance cover would have been put in place. That would have responded in full, alternatively in part, to the liabilities arising from Mr. Kelsall's accident, and would have provided an indemnity in respect of the same being the liabilities. Alternatively, such liabilities would have been avoided for the reasons set out below. Accordingly, this is paragraph 8, the claimant is entitled to damages in respect of the losses it has suffered as a result of there being no relevant insurance cover that responds to the liabilities. Again, it's liability cover. Paragraph 13.1, it's the global liability program of insurance that the claimant had in place. On page 82, at paragraph 18, the complaint is in relation to IMP's German policy of liability insurance being cancelled. Accordingly, the complaint at 21 is any liability to Miss Sage arising out of the accident is not covered under any of the policies of insurance that were put in place by the defendant acting as broker for and on behalf of the claimant, or any other relevant insurance such that those liabilities are uninsured. Again, it's liability insurance. Paragraph 35.1, which is in the particulars of breach on page 86, the complaint is that those liabilities are uninsured necessarily, and the complaint is adequate liability insurance was required. At page, paragraph 35.5 over the page on 87, it's the global liability program. On renewal of the global liability insurance program is a liability insurance. And 36.1-2, the complaint is that we didn't identify the need for insurance cover that place cover for liabilities arising from employees hiring cars. and third-party liabilities arising from employees travelling. And then the complaint at 2 is even without further inquiry, it was obvious there was a need for cover in respect of liabilities arising from the use of motor vehicles, including hire vehicles, by employees while travelling on business in jurisdictions throughout the world, including in particular the USA. And then one gets to 37, which we've been looking at, and indemnity in respect of liabilities to Miss Sage arising from the accident. It's liability insurance.
Yep.
So, of course, I accept that one can have other insurances, and they do not have this particular feature of requiring one to prove the liability. But the pleaded claim against us, and I apologise that it's taken me so long to get us there, is in respect of liability insurance. And that's what gives rise to the first ground of appeal. And the judge proceeded on the basis that he was dealing with liability insurance. So in the judgment on page 57, at paragraph 62, he accepted we were dealing with a liability policy, and that under a liability policy, it's necessary if an insured is to recover, that it be established by the insured that it was liable to the third party, which has alleged that the insured is liable. And then he quotes AstraZeneca, and then a more recent decision of Mr. Justice Jacobs and Technip to the same effect. And then one gets to the position where he deviates in my submission, which is that he considers the position as different as between a broker and a claimant as compared to the claimant and insurer. My Lord, that brings us to ground 1, which is concerned with the proper approach to causation in a broker's negligence action. And in my submission, the approach established in Fraser and Furman, which is the decision of this court, is binding on the judge. And he erred in failing to identify accurately the principle to be derived from Fraser and Furman, and in approaching the decision of Mr. Justice Butcher in Dalland as something different from or deviating from Fraser and Furman, as opposed to a convenient elucidation of the principles.
Just show me what he said was wrong about Fraser and Furman, please.
Yes, well, he says 3 separate things about Fraser and Furman. At 66, he says at Fraser and Furman, he says...
Which paragraph?
Uh, 41. It's on page 52, my lord.
So 41 is wrong, is it?
41 is wrong. The last, it goes wrong in the last 2 sentences. And the reason it goes wrong is because it assumes that as between a broker and a claimant, whether there would have been recovery under the policy or a hypothetical policy that is said should have been placed is to be determined on a loss of a chance basis in all circumstances. Whereas, as I will show you, my lord, there are 2 routes to causation established in Fraser and Furman. The starting point, of course, being that the claimant is entitled to be put in the same position so far as money can do, as if there had been no breach. Where the breach is of a failure to place insurance, the question is therefore, what would the claimant have had, what position would the claimant have been in, had insurance been placed? And the first question is whether on the balance of probabilities, given the past factual circumstances, the claimant would have been entitled to indemnity under the policy if placed. And that depends on the meaning and effect of the policy. And the first question is constant, irrespective of whether there is an actual policy in place or in Fraser and Furman, a hypothetical policy that would have been placed. And that's because in my submission, the question of whether, given the past facts on the proper construction of the policy, the insured would have been entitled to indemnity has to be answered based on the correct meaning and effect of the policy.
So where in paragraph 41 is the judge wrong?
So it goes wrong, my lord, because
Which sentence is wrong?
the brokers argued that since the insurance would have contained a standard clause requiring the insured to take reasonable precautions for the safety of its employees, and that since on the facts it had not done so, the claims against insurers would have failed in any event, and so the broker's negligence had caused no loss.
Is that wrong?
No, that's correct. That's what the position was. What's wrong is it then omits the first decision of Lord Justice Diplock in Fraser and Furman, which is that as a matter of fact and on the balance of probabilities, the hypothetical Eagle Star policy would have had a reasonable precautions clause. The proper construction of that reasonable precautions clause was as it required recklessness instead of negligence. And as a matter of fact, Furman, the employer, had not been reckless. They had been negligent but not reckless. And therefore, any claim under the hypothetical policy would, as a matter of fact, have succeeded. That's the first stage of Lord Justice Diplock's decision in Fraser and Furman. The second stage is he then goes on to consider, in the alternative, even if he's wrong about the proper construction of a reasonable precautions clause, would the insurers, as a matter of business or commercial practice, have taken the point? And he finds that the chances, it being a decision of a third party, the insurers, the chances of the insurers taking a reasonable precautions point that, in his view, was very unlikely to succeed and which would undermine the purpose of an employer's liability policy was nil, because no reputable insurer, such as Eagle Star, would have taken that point. So there are two parts to the decision. And
It's not quite that, isn't it? It's a point which, on the assumption that he's wrong on the first point, which would have succeeded, but which the insurers would not have taken.
yeah, no,
No?
my lord. No. May I take your lordships to Fraser and Furman, please? It's the first authority.
Well, I'd just like you to tell me what the judge got wrong. You must know, and paragraph 41 you now say is not something he got wrong, it's an omission. Where are the other
omission,
two paragraphs that he got wrong?
The omission is the error.
I
Because there are
understand.
two.
I've written that down. I want to see the other two paragraphs where he got Fraser and Furman wrong. You made the submission, Mr. Shapiro, that the judge was wrong about Fraser and Furman in 3 paragraphs in this judgment. I want to note down where that is.
So he then deals separately with the decision in Delland,
I know that.
treating it as somehow different from Fraser and Furman. And paragraph 66 he starts off, and in the first instance he identifies in my submission correctly that Dalland is not authority that the only way in which a claim against an insurance broker can succeed is if the court is persuaded on a balance of probabilities that the claimant would have recovered under the putative policy of insurance. That is a way, it's the first way, and it gives a full indemnity to a claimant who is able to establish that. If, however, this is not established, that's the second route in Fraser and Furman. But the court were to conclude that the claimant has nonetheless been deprived of the chance of a recovery, that a recovery would have been made had the putative insurance been in place, then there will be a recovery, but it will not be in full and will instead be arrived at on a loss of a chance and so percentage basis. And that's the second route in Fraser and Furman. So at that stage, he's applying Fraser and Furman and finding that Dalland is consistent with it.
Finding
That Dalland is consistent with Fraser and Furman.
yeah, so that's not wrong.
But then at paragraphs 83 to 85 of the judgment, he distinguishes Dalland, saying this is not a case, unlike Dalland, where the claimant has chosen not to pursue the insurer and instead only to bring a claim against the broker. This is for a straightforward reason. Norman Hay does not have an insurance policy under which it could bring a claim. And then at 84, for essentially the same reason, this is not a case where, as Miss Justice Butcher put it at 137 of Dalland, anything depends on facts which existed at the time, depending on the nature of the point, either a placement or the occurrence of the putatively insured loss. And that's not correct.
84 is not correct.
Yes.
But it's nothing to do with Fraser and Furman.
Well, what the judge does is treat Dalland is merely a convenient, most recent elucidation of the principles in Fraser and Furman. So in departing from it and treating them as something different, the judge in my submission is erring.
Well, Mr. Shapiro, I understand you say the judge was wrong, but we started all this because you made the submission that the judge had effectively misunderstood Fraser and Furman. And as I understand it, you've now taken us to three parts of the judgment, none of which you say demonstrate a misunderstanding of Fraser and Furman, but the first one omits the liability part of the decision in Fraser and Furman.
Well, my lord, the way the judgment works is that Fraser and Furman falls away, and Dalland is the authority that the judge focuses on.
Yeah.
Dalland, in my submission, is consistent with Fraser and Furman.
Yeah, well, show us now Fraser and Furman and why it means you are right.
So it's in the authorities bundle behind tab 1
Yeah.
on page 3. In Fraser, Miss Fraser had injured her hand when it became trapped in an electric welding machine. She claimed damages against her employer.
It's a fencing case, isn't it?
Yes.
Yeah.
And Furman had no policy of employer's liability insurance because their insurance brokers, Miller, had failed to place any EL policy.
Yeah.
There was the third-party claim between Furman and Miller, which was before this court. It was also common ground that if Miller had placed an EL policy, the policy hypothetically placed would have been with Eagle Star, and any such Eagle Star policy would have contained a reasonable precautions clause. So the first issue, and the one on which this court determined the appeal, was whether Furman had been in breach of the reasonable precautions clause.
Yeah.
And the court then went on to consider, well, would Eagle Star have chosen to rely upon a breach?
I mean, they held pretty simply, that the clause would not have provided a defence to the implies liability cover, but that Eagle Star wouldn't have taken that point, and so that's what they decided.
Yes, but significantly, they decided the first point or Lord Justice Diplock decided the first point on the balance of probabilities.
Yeah.
And the second point, because it was a decision of a third party, on a loss of a chance basis.
No, he doesn't decide the first point on balance of probabilities. You decide facts on the basis of balance of probabilities. This was a legal point as to what was the meaning of the clause. And he says, well, it means recklessness, and there's no recklessness alleged, so the clause isn't going to operate. So the first, and that is sufficient to decide the appeal. He then goes on and says, even if I'm wrong about that, there's another obstacle, and for the purpose of that, he assumes that the insurance company Eagle Star, this is at the top of page 13, had been entitled, as a matter of law, to repudiate liability, but there is a separate question whether, as a matter of business, they would or not. So this latter point arises on the basis that they had a winning point, but they would not have taken it, and he assesses that on the basis of loss of a chance and decides that the chances that they'd have taken the point are zero.
Well, the first question, the legal analysis of the policy, I accept he's deciding as a question of law. But when he decides whether or not they were recklessness, he's applying that question of law to the past facts and doing it on the balance of probabilities.
Right?
But he's doing it on the basis that everybody knew what policy they would have taken, and whether, therefore, is now deciding whether it would have responded. The particular policy that would have or should have been take place that wasn't. We don't have that here.
I accept that, my lord, but we do know what type of policy it is, and we therefore know one of the criteria that have to be satisfied if there is to be a recovery under that policy.
Well, we don't know what type of policy it is, because what is alleged is that there should have been a policy which responded to the problem created by this accident, and either for Norman Hay or for the subsidiary. So it's a very general allegation. Yes, they generally refer to it as a liability policy, but there's no magic in those words. They're just saying, you ought to have placed a policy that covered us, and you didn't. There's no policy pleaded, there's no terms and conditions of that policy pleaded, and we can't therefore engage in the Fraser and Furman analysis.
In my submission, my lord, there is magic in the phrase.
Well, I know that's why you went through drawing out every paragraph in which they said liability, but not the paragraphs in which they say this should have covered us against what happened.
Well, my lord, we do ask them if I can.
No, we're not looking at further and better particulars. I'm sorry. We've been through the pleading. If this case turns on whether or not they've answered a fair question for further and better particulars, then it can't possibly succeed as an appeal, as the judge, having got an Order 14 or Order 24, Part 24, and strikeout application wrong. That's not going to turn on what questions you asked.
My lord, acknowledging that it may be of no effect, please may I ask you just to look at one reference.
Of course, I'll look at all the references.
In the supplemental bundle on page 181.
Yeah.
We ask at 42, please identify the alleged insurance, which the claimant contends it would have had, and set out the terms of such insurance. And
Yeah. The answer is that it's inappropriately duplicative.
Well, the original question is at 6, paragraph 6, on page 160. The question is on page 163.
They say the question is adequately pleaded in paragraphs 37 and 38.
Well, if it's identified in paragraphs 37 and 38, which is a liability policy, which it is, I would invite this court to proceed on the basis that they're contending it's a liability policy.
I just don't. You really are sort of not tackling the point. The point is that they say, but for the defendant's breach of his duty, blah blah, the claimant and/or IMP would have had in place valid and effective insurance cover that would have provided an indemnity in respect of liabilities to Sage arising from the accident. Right? Now, that may be utterly wrong. I don't know. But it depends, doesn't it, on the facts. What policy you would have had in place, what policy was available, what you advised, what they asked for, and all sorts of other things. I mean, you're saying if they'd got a liability policy like was normal, it wouldn't have covered them, namely the claimant. I understand that point. I'm sure it's a very good point. But it may not be the answer to this claim. It may not be the complete answer to this claim.
Well, when this, I appreciate that I'm, that I haven't persuaded my lord.
I'm not persuaded, but I just need to see the argument as to why the judge was wrong. When the judge said this is all about a loss of a chance, lots of things could have happened, and until you have a trial, we can't see what would have happened and how it would have happened and whether they lost any money. Now you make a second point, which I also understand about reflective loss. You say that in reality, probably all this is reflective loss. But again, it's well, I'm not prejudging it. You need to argue it, but it may be that that's a similar kind of point. That probably you're right, but depends on what they ultimately managed to establish you did wrong. If anything, you may have done nothing wrong, Mr. Sperry.
My argument is premised on it being a liability policy. So if this court doesn't accept my submission...
But what is it?
The hypothetical policy, my lord.
That doesn't say that in paragraph 37. It says the claim is that you should have put cover in place that responded.
That responded to the liabilities.
Responded to provided an indemnity in respect of liabilities to Sage arising from the accident. That's not only a liability policy, it might be all sorts of things, I don't know.
Well, it hasn't been contended before this morning that it's anything other than a liability policy during the entire course of argument. It's, as that would have been, if some other contention was being made, as that would have been a complete answer to the application. It's, in my submission, surprising if that hadn't been made, but that was what was in mind. And it's surprising if, given the number of comments in relation to liability policy, and given the complaint that we allowed non-owned auto liability cover to be given up without placing that worldwide, on the face of it, what's being complained is you didn't place non-owned auto cover worldwide, which would have covered the US.
Well, what the judge says, I think, in paragraph 84, is this is not a case like Darland, that's the correct pronunciation, since the present case case involves consideration of a counterfactual, which entails asking what would have been the position had there been a policy in place, which there wasn't. And this involves looking at a loss of chance aspects, what type of policy would have been obtained, what conditions would have that policy have contained, and what was the likely attitude of the putative insurer to being notified by Norman Hay of Sage's claim. And this involves weighing contingencies. How can you say that it wasn't in issue what type of policy was going to be? That's the reasoning the judge gives for dismissing your application.
Well, at that stage, that's the reasoning he gives for distinguishing Dallam.
No, it's the reason he gives. He says this is not a Dallam case. And then he says this is the kind of case of which he explains that. And we need to be persuaded that he was wrong, because that's the function of an appeal. So you may establish very clearly that if a liability policy had been in place, it would not have responded to a claim by Norman Hay, right? Because
Yes.
Norman Hay was not Mr. Kelsel's employer. Get all that, right? But that's not the beginning and the end of it, as the judge said at paragraph 84, probably elsewhere as well. It's a very long judgment for strikeout, and it goes into inordinate detail about Dallam, which seems to me, anyway, you're going to say different, seems to be quite a different case. But there we are. That's the way he did it. When we get to 84, we get to the number bit.
My lord, there are two routes the claimant to recover. Route number one is my lord, Lord Justice Mayall's comment. You analyse as a matter of law what the meaning and effect of the hypothetical policy is, and you apply that to the past facts. And you either get, if the claimant would have had cover under the hypothetical policy, a complete recovery.
Yeah, well, I understand all that, yes.
Or as here,
You get loss of a chance.
you get zero.
Yeah.
There's then a second route, which is a loss of a chance route, and depends on what would the insurer have done. But the starting point of that, as again my Lord Justice Mayall's observed in relation to Lord Justice Diplock's judgment, is was there a good argument or not? And here, any insurer would have known that there was no prospect of Norman Hay establishing that it was liable to Sage, not least because they declined to plead that it was liable to Sage, or subsequently to prove it. And so the chances...
But that's only half the story. The insurer would know that there was no prospect that it was liable to Norman Hay, but it would also know that there was, you'll excuse the double negative, there was no prospect that it was not liable to IMP. In other words, it would know that it was bound to pay one or other of them. That's looking at, for the insurer, looking at this claim and thinking, am I going to get away with this? Don't have to pay. The answer is no, isn't it?
I quibble with bound to pay, but I otherwise entirely agree with my Lord's point that if it was IMP and the complaint was being brought against us by IMP, there would be nothing in this point.
Yes.
That's not what my lord said.
Well, forgive me, in that case I've misunderstood.
The insurer, faced with a claim by Norman Hay, has got a choice. He can either say, no, you're not liable, the only people I'm liable to, you're not entitled, the only people I'm liable to are IMP, in which case there'll be a claim by IMP, or there'll be an assignment of the claim, or he can think to himself, well, it doesn't really make any difference, I'm going to have to pay this claim, I might as well pay it and take a discharge from both companies.
Well, I agree. If both were part of the same group and covered under the same policy, that could well have been the practical result of
But if there had been a policy, that at least arguably would have been flushed out by the time of the sale to Quebec. And if the point had been flushed out, then people would know that it had to be dealt with.
But, my lord, yes, if there had been a policy.
Oh, well, that's the counterfactual we're dealing with.
But in terms of whose loss it is, the insurer would have paid because it was IMP's loss. And they would have paid because it was IMP's liability.
I know.
But so what? Because the position is you should have put in place a policy which covered both Norman Hay and IMP against this kind of problem arising when people hire cars. Had you put in place such a policy, it would have covered all members of the group. When this event happened, the group, as we can expect in an American case like this, they get sued. Everybody gets sued, whoever they are, whether they're liable or not. And the group goes, if there'd been no transaction, the group goes to its insurer and says, look, I've got a policy covering me, it doesn't matter who's liable, you better settle it or deal with it in the normal way. And the insurers would say, of course. They wouldn't argue about whether it was IMP or Norman Hay that was liable to the poor Miss Sage. They would just deal with the case. And all my lord is saying is that the fact that there was what I described as machinations and a transaction doesn't matter, because had such a policy been in place, an arrangement would have been entered into which would have benefited Norman Hay in some way. That is what they're saying, and they're saying they lost the chance of being benefited in that way. Now, it may be very complicated, it may be very simple, but it'll have to be worked out at trial as whether that's right or wrong. It doesn't matter that only IMP is notionally liable under a liability policy if that is what was put in place.
Well, my lord, what also isn't pleaded is there any liability of legal liability on IMP. We asked about that as well. We asked, are you alleging? So we specifically tried to address, not as elegantly.
Well, that's because there's lots of arguments about Mustangs and going to parties and all that kind of thing. But I mean...
Well, that wouldn't prevent the pleading, my lord. They have the option of pleading and prove... Sorry.
Why does it matter?
Because unless they can plead and prove that IMP was liable, the same points arise as against IMP. The insurer doesn't have to pay. Now, it may be that adopting the kind of approach of Lord Justice Mayles was identifying, that the insurers and IMP stroke Norman Hay would have come to some kind of accommodation. And that could have been pleaded. That's a very narrow case on a loss of a chance basis. And the essential first step to it would be, is IMP legally liable to Miss Sage? Because if they're not, exactly the same argument exists as against IMP. And there must be a reason. We're in a situation where there is a specific refusal to disclose any of the advice given in the US as to the settlement being entered into. So we don't know why it was entered into, and they say that they won't disclose it.
Well, that's privileged, and we're not supposed to draw inferences against somebody when they exercise a right to privilege, which is said in a whole host of cases to be a fundamental right.
Yeah, I'm not asking you to draw an inference, but I am asking this court to take notice of the fact that they would have to prove a legal liability and that the settlement was reasonable. And the assumption underlying, and it was a perfectly reasonable assumption, but underlying the point I understood my Lord Justice Mayles was making to me, was that it would be easy for IMP to show that it was legally liable to Ms. Sage. But here we have a very curious situation where they also declined to plead that IMP was legally liable to Ms. Sage. And if IMP is not legally liable to Ms. Sage, that would be the necessary starting point for the insurer to decide, am I going to pay any of this claim? And they would have to assess what's the risk of Norman Hay and IMP together being able to establish that one of them was legally liable to Ms. Sage. And at the moment, the obvious inference from the fact that they refused to plead that they were in fact liable to Ms. Sage is there's zero risk. There's no reason pleaded for why, in the normal course of things, of course I accept that most insurance disputes end up being settled. Of course I accept that insurers take a pragmatic view. But in relation to Omega, in relation to AstraZeneca, in relation to Technip, in relation to Enterprise Oil, insurers have all taken the by now very well-known point that you have to establish a legal liability in order to recover under a legal liability policy. And here, my learned friends have deliberately declined to plead not just that Norman Hay was legally liable to Ms. Sage, but also that IMP was legally liable to Ms. Sage. So I very much accept my Lord Justice Mayall's practical route, but because of that refusal to plead and prove IMP's legal liability to Ms. Sage, that, in my submission, doesn't help them either. The same point arises. My lords, I was going to take my lordships, your lordships, through the Fraser and Furman line of authorities. I suspect that the principles may not need that elucidation. I can do, they're consistent. But what they're saying while we're, if you still have it open, tab 1 of the authorities bundle. Lord Justice Diplock on page 904 of the report, page 9 of the authorities bundle. He's identifying the obvious point that the employers are according, this is at B, entitled to be put in the same position as far as money can do so, as if the contract had been performed by the brokers. If the contract had been performed by the brokers, the employers would have been parties to a policy of insurance against employers' liability in standard form, underwritten by a first-class insurance company of the highest reputation. As a result of the breach, they were not insured at all. And then he says, what damage they have suffered does not depend upon whether Eagle Star would have been entitled as a matter of law to repudiate liability, but whether, as a matter of business, they would be likely to do so. What the employers have lost is the chance of recovering indemnity from the insurers. If Eagle Star would not have been entitled to repudiate liability law, the question falls away. Damages recoverable would amount to a full indemnity. So that's the first route. If the court decides a combination of legal analysis of the policy and the past facts to be determined on balance of probabilities, that there would have been entitlement policy, that's full recovery. Alternatively, even if they would have been entitled in law, however, to repudiate liability, does not, in my view, follow that the employer would be entitled to no damages. The court must next consider, and the reason it's next in my submission is because you start from is it a good argument or not? What were the chances that an insurance company of the highest standing and reputation, such as Eagle Star, notwithstanding their strict legal rights, would, as a matter of business, have paid up under the policy? And then, over the page at 905, below paragraph B, letter B, the first point to consider is the question of construction of that condition, which is my Lord Justice Mayall's legal point. Over the page at D, on that construction of the condition, which seems to me to be implicit, I next turn to the facts of the case, and then from Miss Fraser was injured onwards, through to H, on page Authority Bundle 12, page 907 of the report, he decides on the balance of probabilities, were they in fact reckless or not. Then he goes on below H, even however, if I were wrong upon the construction of condition 4, that's the reasonable precautions clause, there is, in my view, as I've already indicated, another obstacle which would lie before the appellants in this case. So that's separate from the first one. The general rule which I've stated as the measure of damages is that employers are entitled to be put in the same position. Accordingly, this is over the page, the court would have to consider, assuming that the insurance company Eagle Star had been entitled as a matter of law to repudiate liability, whether they would, as a matter of business, have done so. And he goes through, and at C, over the page on 909, he's disposed of an argument that doesn't need to trouble us by this stage. In my view, therefore, the court has to consider whether or not, in the circumstances of this case, assuming that I am wrong in the construction which I have put upon condition 4, the particular insurers contemplated as such by the contract, namely Eagle Star, would have sought to rely upon this condition to repudiate their liability under the contract. And he recognises no evidence from Eagle Star. And then under E, if I can invite your lordships just to read the paragraph in considering down to dubious, he sets out a series of reasons why, in his view, Eagle Star would not have taken the point. And they're good rational reasons why an insurer of Eagle Star standing would not, in an EL policy, have taken a point such as a reasonable precautions clause, undermining the purpose of the EL policy.
Yeah.
And then he says, when all these matters are taken into consideration, with the additional fact that although, if Mr. Hurst's construction is right, a high proportion of claims under EL policies could be defeated by relying on the condition, there are very few reported cases of insurance companies having done so, and none to which our attention has been drawn in which they have done so successfully. It seems to me to be highly improbable that, as a matter of business, a company of high reputation would conceivably take this wholly unmeritorious point in a claim of this kind. And he finishes, accordingly, even if I had been wrong on the first point, I would have dismissed the appeal on the second point. So there are two routes to recovery. The first is simply, are you entitled to indemnity? And it is important that that's a yes-no answer, because as soon as one introduces loss of a chance, one ends up with a discount. So, for example, where it's being said that one looks not at whether there was an entitlement to cover under the policy on the past facts, but what a court would do in relation to the particular policy, one inevitably penalises the meritorious claimant and benefits the unmeritorious claimant. And
not on the facts of this case. If we assume, as you ask us to, that this was the hypothetical policy was a liability policy, and if we ask then whether Norman Hay would have been liable under that policy, it makes no difference, does it, whether we apply balance of probabilities or there would have been zero chance.
I agree.
That makes no difference.
I agree. But the judge didn't go on to consider whether or not there was a substantial chance or not of an insurance company paying where there's no legal liability, either on the claimant or, importantly, in view of the argument this morning, on IMP. That doesn't feature in the judgment. The submission is recorded at paragraph 33. But there is no answer to that question. But leaving aside the present case, as a matter of principle, in my submission, it's right that whether a claimant would be covered under the hypothetical policy they might have had if the broker hadn't been negligent is decided on a yes-no basis. Because otherwise one runs into the problem one has in relation to deciding matters where litigation is lost. So in all the cases where litigation is lost, which are reviewed in Perry and Rallis, generally the litigation has lost because it's no longer in a situation where there can be a fair trial. So necessarily the court cannot do, and it would be wrong in principle to do a trial within a trial. You've got to assess the merits of the litigation. But if you're assessing the merits of the litigation, the top end of your likely percentage is not going to be higher than 75%, because who gives better than 75% prospects in any litigation? And so you have a claimant where they might have a claim for 75%, a claim with 75% prospects of success. If that had gone to court, they would almost certainly have won, probably what 75% looks like. But they recover on a loss of a chance basis only 75%. Conversely, if you have a claimant who's only just got a bit better than litigation risk prospects of success, let's say 30%, probably, if the trial had fought, they would have lost and got nothing. But on a loss of a chance basis, they're better off. And so if loss of a chance is applied more generally to brokers, causation of brokers cases, without the initial first question of a yes-no answer, you have undercompensation of, as suppose one has a householder and there's a failure by the broker to place a policy of household insurance, and then there's a flood. On a yes-no basis, they get the full indemnity. On a loss of a chance basis, they have to argue whether or not the insurers would have paid or agreed, or what the court might have done. And on the face of it, if in a lost litigation case, one tends not to get findings that there was a 100% chance before a court, which is rare, then you're not going to get 100% recovery. So the principle of how you approach it does make a more general difference. I respectfully agree with my Lord Justice Mayall's point that in this case, on my submission, it makes no difference, because you get a no answer on one basis and you get a nil prospects answer on the other basis, because what insurer, with their duties to their shareholders, is going to provide an indemnity without any positive reason for doing so? But the householder provides, in my submission, an explanation for why this particular point of principle matters. And one could, say, develop the example. Suppose there's a condition in the policy, which there may be, as to occupancy of the property, and the householder has been away for a couple of months and is in breach of that condition. On the face of it, there might not be entitlement under the policy to recover, but an insurance company might well consider, was it an instance where the river door flooded, in which case it doesn't make any difference how long somebody's been away from a property? Or was it an instance where a slow leak developed over 2 months into a burst and a flood? The two routes in my submission, while they result in the same, certainly on my analysis, same result in this case, are more generally equally important and might result in different results in other cases. It can't be right in my submission that simply in a professional negligence action you always assess matters on a loss of a chance basis. One's got to look, and that's Perry gives the lie to that. One's got to look at what the claimant would have done and what would have happened on past facts on the usual basis. It's only decisions of third parties which are on a loss of a chance basis. And if one's asking, well, would there have been on these past facts a entitlement to indemnity under the particular policy, that should be answered on a yes-no basis for itself, applying the law of the meaning and effect of the policy to the past facts. One shouldn't try to ask some derivative question along the lines of what would a court have decided. That's asking the wrong question, and it results in my submission, percentage answers which aren't appropriate in these circumstances. My lords, that's in my submission, that is the principle that can be derived from Fraser and Furman. One's got the two routes. And where the judge goes wrong initially is only identifying the loss of a chance route, not the yes-no route. And then where it goes wrong next is not answering, and this is ground 2, what the position is as to whether there was an entitlement under the liability policy. Because here we know that there is no pleading, and therefore it won't be proved that Norman Hay was liable to the claimant. To answer the concern of this court this morning, we know that there is no pleading that IMP was liable to Miss Sage, and therefore no prospect of it being proved that IMP was liable to Miss Sage. So whether there had been a policy in place covering both the claimant and IMP, there was no entitlement, at least as things are pleaded now, to indemnity. If I could ask my lords just to turn in the judgment, the judge's judgment in the core bundle at tab 5 on page 52, please. Norman Hay's position, and this was only stated in relation to Norman Hay because the IMP issue wasn't approached in the same way first instance as it has been by this court. Mr. Chapman, King's Counsel, on behalf of Norman Hay, submitted as to the liability issue that Marsh is simply wrong on the law since it is not necessary.
So which paragraph are you
I'm so sorry. 39 on page 52, my lord.
Thank you. And
they accept that they're not going to show that Norman Hay was liable in law, I hesitate to, or I won't take my lords back to the reply to the request for further information, but the same disclaimer and decision not to plead that IMP was liable to Ms. Sage is made, and we covered that in the request for further information, asking specifically, are you saying that IMP was liable? And we got back an answer which was to cut and paste from the existing pleadings without saying, yes, we say IMP was liable. And so, in my submission, having recorded the position, and on the basis of the position in AstraZeneca, the judge should have found that there would have been no entitlement to indemnity under a liability policy for Norman Hay. And the same finding would be appropriate in relation to IMP for the same reasons on the same pleading, but that issue wasn't before, or wasn't canvassed before Mr. Justice Picken. And that then is the starting point for any loss of a chance case which is found to be pleaded. And this is ground 3 of the appeal. May I ask you please to turn through in the judgment to page 66, paragraphs 92. The 92 conveniently quotes paragraph 41 of the particulars of claim. Alternatively, as a result of the defendant's aforesaid breaches of duty, the claimant has lost the opportunity, so that is a loss of a chance, of obtaining insurance cover that would have responded to the liabilities arising out of the accident. That's liability cover. And at 93, the judge says, I appreciate this does not spell out that Norman Hay's case is that the putative insurer would be expected to adopt a pragmatic and reasonable, and pragmatic and commercial stance if faced with a claim by Norman Hay, based on the fact that Miss Sage had herself made a claim. That is not in the pleading. And the reason, based on the fact that Miss Sage had herself made a claim, doesn't take one anywhere. Because it's not the fact of Miss Sage's claim which matters or is going to affect the insurer's decision. It's the question of, is there a reasonable prospect of Norman Hay or IMP, on Lord Justice Mayos' approach, being found liable to Miss Sage? And that's just not being alleged. There is no basis, and no basis will be put before the court because it's not being pleaded, as to why an insurer might conclude that it had any liability to Miss Sage. It's simply not being contended. And this paragraph doesn't plead, for example, anything about what an insurer would do. It just talks about what the putative policy would do. There's nothing said about the insurer. There's nothing said about commercial or business purpose. There's nothing said about any reasons. And necessarily, having not pleaded what the risks are in terms of any finding of liability, one can't know what the insurer would do beyond knowing that as things stand and as presently pleaded, it has absolutely no obligation to indemnify because there is no allegation that Norman Hay or IMP was in fact liable. In relation to the other way it's put, turning now to ground 4, if I can ask your lordships to turn through to page 51 of the bundle and to paragraph 33. The judge recorded my submission that in the context of a professional negligence claim brought against an insurance broker, where the claim is alleging a failure to obtain insurance, claimant must plead in... sorry, I'm reading the wrong paragraph. My submissions, there are good reasons for this approach, primarily because the basis on which it is decided whether or not there would be indemnity under a policy should be the same in a claim against insurers or a claim against brokers. In any event, even if the correct approach was on a loss of a chance basis, it would be necessary for Norman Hay to show that it had lost a substantial chance of indemnity under the putative policy. Plainly, if there's no entitlement to indemnity at all, there is no substantial chance of indemnity. And the judge failed to address that issue, whether there was any substantial chance of indemnity. There was an observation during argument at day 1, page 174, it's in the supplemental bundle at 295. The judge observed that he didn't think Mr. Chapman is going so far as to say that an insurer would have paid, knowing full well there was no chance at all of being on the hook. But that is the present position, because the insurer would know that there's no attempt to establish any liability, either of the claimant or Norman Hay, to Miss Sage, and therefore the insurer is simply not on the hook. And that's the essential starting point. From that starting point, why would an insurer have paid? There is no reason, and absent any pleaded case with some particularisation, one ends up indulging in speculation. I've already identified that paragraph 93 of the judgment, the judge speculated that it might have paid a claim based on the fact that Miss Sage had herself made a claim, and that doesn't follow logically. The other way he put it was that on page 59, paragraph 64, it starts on page 58. That will include the court asking itself whether realistically the putative insurer would in the present case have told Norman Hay that should in effect act as a prudent uninsured in dealing with Ms. Sage's claim, or whether, as Mr. Chapman, King's Counsel, would suggest, the more likely position would be that the putative insurer would have engaged with Norman Hay in dealing with the claim and provided an indemnity of some sort. Well, that begs the question of why. If the insurer knows that there's no prospect of either the claimant or IMP establishing a legal liability, on what basis can the insurer abide by its duty to its shareholders and pay the claim? And there certainly wouldn't have been any commercial reasons to do so, because Norman Hay had by this stage ceased to trade and was in administration, so there's no further business coming or anything of that nature. At 67, the judge says, tries another approach and suggests, this is starting at the fourth line, or in a lesser amount, assessed on a loss of a chance basis, because the court is persuaded that in all likelihood the putative insurer would have taken a pragmatic and commercial stance, which would have seen it pay a partial indemnity. And this is where it goes wrong. thereby avoiding the risk that Miss Sage's claim was not settled, and so she ended up receiving more than US dollars 5.5 million, which she agreed to accept, and that the insurer was ultimately found to be liable to provide a full indemnity. If there's no basis for the insurer to give an indemnity, that's simply not a risk. And strikingly, in my submission, what's absent in this case is any reason, any business or commercial reason for an insurer to pay either a full or a partial indemnity, notwithstanding it has no legal obligation to do so. And without turning it up again, I compare the position in this case to that in Fraser, where there's very good reason. It's an employer's liability policy. The reasonable precautions clause was totally unmeritorious. The position, if it was right, would be that employers' liability policies would be very seriously undermined. There were all good reasons for Eagle Star not to take that point, and even more so in the later case of Dunbar, again before this call, by which stage the Employers' Liability Compulsory Insurance Act was in place. And if one, as an employer's liability insurer, starts refusing to pay claims under employers' liability policies, then one undermines the purpose of compulsory insurance, as Lord Justice Balcombe noted in this court in that case. There are no such comparable factors in the present case. We're squarely in the AstraZeneca, Technic, Omega Proteins line of cases, where insurers have seen that they don't need to pay judgments just because there's a fear of US juries. Don't need to provide indemnities just because there's a fear of US juries, if in fact there is no legal liability between the insured and whoever is suing them.
Would it be fair to call that a question of fact rather than a question of law?
Well, that last bit, yes, is a question of fact, but it's right on a summary judgment application to take into account whether there is any basis for a particular contention to succeed. And we have asked for it to be pleaded, and indeed the Mr. Justice Picken gave the opportunity for amendments to be made. There was a date by which they had to be made. No amendments were made. And there was an exchange at the consequentials hearing about, are you really not going to amend? Answer, no. And in my submission, applying the approach of Mr. Justice Lewison, as he then was, in Easy Air, the court does have to consider, is a particular contention likely to be made out? And in this respect, if I could ask Your Lordships, please, to turn through behind tab 10, page 148, and paragraphs 53 to 58 of the respondent's skeleton. There's various complaints about how the point has been put and whether or not we've pleaded the point, but singularly lacking from this section is any single reason whatsoever for why, given that they won't allege either that IMP or Norman Hay was liable to Ms. Sage, any single reason for an insurer nonetheless to pay either a full or a partial indemnity, despite having no legal obligation to do so. in my submission, we're in the same position that Mr. Justice Flo, as he then was, identified in the first instance decision of AstraZeneca, whereby it's then behind tab 8 of Your Lordship's bundles. It's paragraph 10 of his judgment. By this stage, one has the first instance decision of Mr. Justice Aikens in Enterprise Oil, saying, no, you've got to establish legal liability and also your settlement was reasonable. One then had the Omega Proteins judgment of Mr. Justice Christopher Clark, as he then was, before he was elevated, saying exactly the same thing. And it was well established and well known to practitioners at the time. And Mr. Justice Flo identified at 10, it's a striking feature of this case. The claimant does not advance a positive case that AZ would, on a balance of probabilities, have been liable for the claims in question, assuming a correct application of the law governing the claims to evidence as properly analysed. That being the test is a matter of English law. And in my submission, the position adopted is equally striking here. And doubly so, because before bringing this application, we, possibly labouring the point, but gave them every opportunity to plead in the response to the Part 18 request, yes, we are alleging claimant was legally liable to missage, or yes, we're alleging IMP is legally liable to missage. And there was an absolute refusal to go down that route.
I understand your point that they haven't pleaded it, but if Mr. Kelsall was driving negligently, which you accept he was because he was driving on the wrong side of the road, and if he was an employee of IMP, which you accept we have to assume for the purpose of this appeal, then how could IMP not be liable to missage?
Because that part of the trip wasn't for business purposes. He was visiting two people who had been formerly, they had been business colleagues, but they had left, each respectively left the customers that they had formerly worked for.
He was driving to the airport to go home on a business trip.
Well, I said he was driving to the airport to go home following his business trip. But the reason he was flying out of that particular airport, having hired a car to drive 4 hours to friend number 2, was because he had perfectly reasonably decided to visit friends at the end of his business trip. But if it, my Lord, in my submission, the best answer to my Lord's question is, if it is obvious, why then does the claimant not plead it and prove it?
Well, we can ask Mr. Chapman.
But I'm sure your Lordship will, but in my view, it's because it's not as obvious on the facts of the case, and I appreciate that that factual question can't be matter for summary judgment. But if they had wanted to, they could have pleaded the legal liability. They've had every opportunity to do so. They've refused on every occasion to do so.
There was no argument before the judge, and there's no ground of appeal about whether or not IMP was liable.
Well, my Lord, it wasn't put. My Lord have put it differently in this court than how it was put at first instance, where the matter is pleaded, and it's exactly the same argument, and it was raised as but surely even if you're right on the claimant's point, it would be there would be an indemnity given to IMP, to which, whether it was raised by before, a reasonable response is, well, that hasn't been pleaded either. and indeed they've expressly disclaimed making any such allegation. And in my submission, if the claim is bad at the moment, and I may have a very long way to go to persuade my lord of that, but if it is bad at the moment on that basis, and that's the way they're pursuing the claim on the pleadings, then it should be dealt with on a summary judgment. They had every opportunity to amend. They had every opportunity just to say in response to it. They didn't even need to amend. A response to a Part 18 request counts as a pleading, counts as a statement of case. They could have just said, yes, we allege that IMP was liable to Ms. Sage. They expressly did not do so. And therefore, if we continue to trial, absent amendment, which they say they're not going to do, the claim will fail on that basis. And it should therefore be dealt with now because it has no real prospect of success accordingly. My lord, that takes me to ground 5. The orthodox loss claimed in a broker's negligence action is obviously the absence of insurance cover for the claimant entity, resulting in a loss sustained by the claimant entity. And here the difficulty is that the route of, say, an assignment wasn't taken, and Norman Hay has no entitlement to claim a loss suffered by any entity other than itself. And presumably because of the difficulties in contending that Norman Hay would have received an indemnity under any liability policy, and for whatever reason the difficulty in alleging that IMP had legal liability, Norman Hay has claimed various different losses, all of which are essentially Norman Hay seeking to claim the loss suffered by its former subsidiaries or other entities. And the first thing was it appeared that Norman Hay was bringing a claim for the lesser value of the shares in the subsidiaries, equal to the amount of the Sage settlement sum. And that appeared from, if you would turn up, please, my lords, page 121 of the core bundle. Paragraph 11, the response to the paragraphs of the on loss that we looked at briefly when I took you to the wrong place earlier is here. As to paragraph 9, the Sage settlement sum is paid by the claimant through a joint instruction with the buyer from funds held in an escrow account constituted as part of the sale of the claimant's former subsidiary to the buyer. This reduced the sale sum paid to the claimant, causing the claimant loss. And if I could ask your lordships to turn back to page 53 in the bundle. I'm so sorry, page 56, paragraph 53 of the judgment. Mr. Chapman, King's Counsel, explained that the settlement sum was thereafter paid by Norman Hay through a joint instruction with Quaker from the funds held in the escrow account, resulting in a lesser purchase price ultimately being paid to Norman Hay, which was equal to the amount of the settlement sum. That, Mr. Chapman noted, is the loss that has been sustained by Norman Hay, which it seeks to recover from Marsh in these proceedings. The fall in value of the shares. And in my submission, leaving aside that no duty to protect the share price of the subsidiaries was pleaded, Norman Hay cannot recover a loss being a lower received price for the value of the shares of the subsidiaries. And that appeared to be recognised because at 55, Mr. Chapman confirmed that Norman Hay was not seeking to put in its damages claim on a basis which reflects the loss in value of its subsidiaries in the Quaker sale. So he's confirming that he's not seeking that loss, while identifying that that is in fact the loss being claimed on the face of it. In my submission, there's no basis for any possible claim for loss of value of the shares of the subsidiaries. Alternatively, Norman Hay seemed to be claiming loss, which was really a loss suffered by the subsidiaries. And that's inherent in the SPA indemnity. The easiest, quickest place to access it is probably page 55, paragraph 49. 50 and 51 are the relevant parts of the sale and purchase agreement. The seller's giving an indemnity to the buyer in an amount equal to the recoverable liabilities which the buyer or any group member incurs or suffers, in each case arising out of or in connection with the indemnified incident, which is the accident. So by the SPA indemnity, Norman Hay is agreeing to indemnify the former subsidiaries, or Quaker, against a loss that is suffered by the former subsidiaries or Quaker. Because if it wasn't their loss, you don't need this indemnity. It's just simply the loss of Norman Hay. They can be paid the full purchase price up front, and they can pass on any part of that they consider they wish to Ms. Sage. It's not Norman Hay's loss, save to the extent that Norman Hay has voluntarily assumed a contractual obligation under the safe settlement agreement and the term sheet to another. And even then, it's only a contractual obligation limited to the extent of the amount placed in the escrow account. So if Ms. Sage's claim had been over US dollars, 8 million, say it had been 8.5 or 9 million, the extra 0.5 or 1 million US dollars would have been met by Quaker because the indemnity was so limited. And that further shows that in truth, this is the loss of the subsidiaries and or their new owner Quaker, not Norman Hay's. And that's why Quaker wouldn't hand over 8 million of the purchase price to keep that in escrow to pay the likely settlement sum that was then estimated. And one can see that it's the purchase price further from the fact that the 2.5 million left over from the settlement of 5.5 million was paid along with interest on it to Norman Hay, that being the balance of the purchase price, whereas the interest on the 5.5 million used to fund the settlement goes back to Quaker, because that reflects that it's Quaker's money, the 5.5 million. The paragraph, I'm conscious, my lord, that
yes, how long have you got?
5 minutes, but that won't make it any more convenient.
No, we still need to rise now, so let's do the 5 minutes at 10 to 2.